Welcome to Bond University on iTunes U.
Well, good morning everybody, and welcome to the courts and the media in the digital era. My name is Professor Patrick Kaiser and I'm the Director of the Centre for Law, Governance and Public Policy, and I'm one of the co-conveners for today's event. It's an event that we're putting on together with the Centre for New Media Research and Education, and later today I'll introduce my conference co-conveners, Associate Professor Jane Johnston and Professor Mark Pearson. This morning we have some outstanding keynote speakers, and we're absolutely delighted that you could make your way to Bond here this morning through the humidity and in spite of the signage to be with here pretty close to time. We've got a packed program today, so we'll have to be vigilant about keeping to the timetable, but we're very interested in what the keynotes have to say. So if you feel like going a little bit over time, you're allowed to do that, but only if you're one of the keynote speakers. I'm going to be the MC today and also the Sergeant at Arms, just in case anybody doesn't behave themselves. Let me give you some quick housekeeping announcements before we kick off. You're aware that the toilets are located. If you go to the lee area of the foyer, there's a door which is located near the registration desk. If you go past that door and then go off to the right, you'll find the toilets. If you're having any difficulty finding them, then let me or one of the conference staff know. You'll know who the conference staff are because they are milling around attending to everybody's needs, and there'll be someone stationed behind the registration desk at each break to answer your questions. Could I ask you all to switch your mobile phones to silent, please, because this event is going to be recorded audially, if that's a word, and also visually. We are going to keep a record of this, and we're hopeful that we'll have that located on the Centre's website in the not-too-distant future. As some of you may be aware, Radio National will be recording the middle session, the post-keynote session this morning for use for their purposes, most likely the law report, given that that session is going to be chaired by Damien Carrick. And we'll also be taking a transcript of today's events so that we can publish conference proceedings a little bit down the track. So thank you for placing your mobile phones on silent. Can I ask you to exercise care around the audio-visual equipment? You may find from time to time that camera operators and other people of that variety will be stepping in front of you to take photos and to take shots. Of course, I'm sure you'll sacrifice your personal space to ensure that the public has the right to know, and you'll allow them to get on with their work, because that's what we're about today. You can tweet as much as you like. This is a tweet-friendly event. We encourage you to tweet, and now it gives me great pleasure to introduce the Chancellor of Bond University, Helen Nugent. Chancellor Nugent is Director of Freehills Lawyers, Origin Energy and Macquarie Group. She's also Chairman of Funds South Australia. In addition to being Chancellor of Bond University, she's President of Cranbrook School. She is going to formally welcome you to Bond University this morning, and I hope you will join with me in welcoming Chancellor Nugent to do precisely that. Chancellor.
Chief Justice de Jersey, Justice Levin, Senator Brandis, Mr. John Hartigan, dear friend, other distinguished guests, ladies and gentlemen. It gives me great pleasure to welcome you to Bond University and to this significant conference on the courts and the media in the digital age. Before I make some introductory comments, let me acknowledge the traditional owners of the land on which we meet, and let me also pay my respects to their elders, both past and present. Associate Professor Jane Johnston, Professor Patrick Kaiser and Professor Mark Pearson have indeed assembled here today a remarkable group of outstanding presenters, and we are extremely fortunate that you have given up your Saturday to be with us. We understand what that means. Family time is indeed very precious, and we really indeed thank you for that. When Patrick informed me he was organising this conference, I was extremely excited and absolutely intent on attending. However, to my great chagrin, I found that this meeting conflicted with a date that is absolutely sacrosanct in any Chancellor's diary, and that is graduation ceremonies. We have, in fact, 2 graduation ceremonies today, and unfortunately I'm going to have to escape very shortly after I open the conference to confer degrees on some very bright-faced and bushy-eyed students. And it's just a wonderful thing to see them around campus with their families. And indeed, we're very fortunate to be having not just this distinguished group here today on campus, but also Margaret Jackson AC, who is giving the occasional address today. So I will have to beg your forgiveness and have to depart shortly. Having said that, I know a lot of very interesting questions will emerge from the meeting today. First, should courts suppress the details of cases to protect people accused of crimes? Or is there an overriding public right to know the identity of the accused and the details of allegations against them? And I know that there'll be some very interesting perspectives on that. Second, should the courts allow television cameras in so that the public can better understand the workings of the court? Or is there a risk that increased coverage of court proceedings will jeopardise the individual's right to a fair trial? We all know how much the internet and social media, like Facebook and Twitter, have changed our lives. Indeed, we're seeing governments brought down on the back of it. But do we know more or less about the courts now than we used to? As the former Chief Justice of the Federal Court, the Honourable Michael Plack, observed at a conference convened by our own Patrick some 12 years ago on the courts and the media, and I quote, "There are few topics more important than public access to the courts and public confidence in them. Independent courts in which the public has confidence underpin our democratic process of government." Today's conference is important because it concerns the even larger and more fundamental matter of the broader need for a well-informed society. That would be a society better able to make decisions about itself based on an understanding of all its institutions of government. This is a matter of profound importance. End of quote. Those words still resonate today. I congratulate the conveners of today's event. I thank all of you, but particularly our guest speakers, for coming to Bond. Please enjoy, may I say slightly immodestly, our beautiful campus. I wish you all the very best in your deliberations, and I look forward to reading the conference proceedings and the podcast, which I understand will follow. Thank you very much.
Thank you very much, Chancellor. I noticed that the some out-of-date information is located on the screen above us, and I will chastise our graphic artist in due course for this oversight. We have the Shadow Attorney General with us today, not the Attorney General, and we've placed an incorrect copy up there. I hope you'll forgive us, Senator Brandis, for that oversight. I think we've got the correct one over here on the left. Ladies and gentlemen, it gives me great pleasure to introduce our first keynote speaker, Chief Justice Paul de Jersey, who's a Commander of the Order of Australia. Chief Justice de Jersey has had a very distinguished career as a jurist, not only in this state but nationally. He holds honorary doctorates from the University of Southern Queensland and the University of Queensland, and I'm sure at some point in the not too distant future he'll receive the more significant honour of an honorary doctorate from our university, and another oversight on our part, I would say. He was awarded the Australian Defence Medal in 2007, the Centenary Medal in 2003, and as I mentioned before, was made a Companion of the Order of Australia in 2000. He was appointed to the Supreme Court of Queensland in 1985, and then to the position of Chief Justice of Queensland in 1998. If I can say on a personal note, Chief Justice de Jersey has been a person who's been out at the forefront in amongst Australian judges in speaking about the relationship between the courts and the media. He's delivered a number of important speeches on the topic, and so it was absolutely essential that we had him here today, and I'm very, very pleased that you could make your way down from Brisbane to be with us, Chief Justice. So I'm sure you'll welcome the Chief Justice in the traditional way at this point. Thank you very much.
Professor Kaiser, ladies and gentlemen, since my appointment to the bench in 1985, I have been centrally interested in the way the judicial mission is presented. About the time of my subsequent appointment as Chief Justice, there was published, under the auspices of the Australian Institute of Judicial Administration, a Courts and the Public report, which presented the courts in a most unflattering light, out of touch, perhaps irredeemably so. I didn't at the time see that as the reality, and over the last 13 years especially, I've striven to let people know that our courts are obviously in tune with the communities from which they are in fact drawn, and of which in fact they form part. On one level, the courts must operate with a degree of detachment. To preserve their authority, they must. A judge who imprisons an offender can't be just one of the crowd. That aside, however, judges' feet are very much on the ground, and to suggest that the criminal court in particular is divorced from the community conveniently ignores the pivotal role of the jury. Increasingly, the symbolism of the law focuses on courts as institutions of the people. Our new Metropolitan Supreme and District Courthouse in Brisbane, currently under construction, as an example, is substantially a glass building, with little barrier to, representing, of course, thereby the transparency of the process which goes on inside, with little barrier to substantial public involvement. Indeed, those who choose to remain in the plaza outside will have fairly uninterrupted views of what's going on inside. Why then are our courts nevertheless perceived as detached from the community? That suggested detachment is most frequently alleged in the context of the sentencing of criminal offenders. Judges are portrayed as either hawks or doves, with the doves pilloried. Legislatures respond to public pressure by introducing mandatory sentencing regimes, grid sentencing, fortunately in Queensland to only a limited extent so far. Legislatures establish sentencing advisory councils, partly, I suspect, in the hope their work will deflect attention from the doings of the blinkered and obdurate judiciary. Why this persistent criticism? The reason is simply this. The courts do not, with any great facility, communicate to the general public the reality of what they do. The work of the courts is, I suggest, the least understood operation of government. We struggle to address this, primarily, of course, by always publishing reasons for the decisions which are given. But who reads them, other than the parties to the particular proceeding? The courts are almost invariably open to the public, but rarely more than a handful of onlookers attend. The open days are popular, but is that for the sausage sizzle and the balloons for the children? We produce educational tapes and videos. We educate our staff, and judges address community groups. In Guam, as I recently discovered, the court has Meet the Judge programs. In this country, Chief Justices participate in talkback radio and are commended for that. But the ABC's morning program catchment accounts for only a fraction of the South East Queensland population. We try, but the bloggers are unforgiving, as we especially note when details of judges' international travel are disclosed, which we in Queensland choose to do on a regular basis. Enter the media. Courts regularly acknowledge that the media plays a potentially important role in publicising the work of the courts. Again, dipping into the criminal arena, assuming deterrence works, securing deterrence depends on awareness of sentences imposed in like cases, and that's primarily secured through publication in the news media. There is persistent complaint from the courts, however, about a lack of comprehensiveness in that reporting. Most courts have sought to redress that, at least in part, by engaging media liaison units. But they have not successfully countered the understandable interest in some media outlets in titillating rather than informing, although the basic business of the courts is obviously much less titillating than WikiLeaks. The media sometimes responds to such complaints by suggesting the courts are insufficiently cooperative and proactive in facilitating media access to court proceedings. This debate has been running for as long as I've been a judge, but I sense it's become more engaged over the last 10 to 15 years. The media also, and I think rightly, complains about denial of access to tendered documents. There must be free access, absent compelling privacy concerns, and likewise suppression orders, which have become commonplace in some jurisdictions elsewhere, should be an absolute rarity. We have in this state developed rules to facilitate media access to exhibits, for example CCTV footage in criminal cases. Access generally arose more specifically recently with revival of the debate whether court proceedings should be televised. There has, I think, been a mixed reaction to the New Zealand experiment in that. I remain a sceptic about whether televising court proceedings will effectively enhance public awareness of the work of the courts. The vast majority of what goes on in the courtroom would be regarded by most people as extremely uninteresting, raising the real prospect that the media would replay only the dramatic bits, leading to a distorted perception of the overall proceeding. And I have a greater concern, and that is what I see as the inevitability that the presence of a camera, however discreetly placed, will distract participants in court proceedings from the serious business at hand. So I don't personally favour the televising of court proceedings, save for the delivery of judgment in important cases where the judge can present a concise and brief synopsis for public consumption. An argument, of course, is that the televising of court proceedings, or in more contemporary terms, the full digital streaming of court proceedings, is simply a rational concomitant of public availability, of the transparency of which we talk so much. I'm not convinced of that. Transparency is sufficiently secured by current approaches, although I note that the sittings of the Queensland Floods Inquiry are fully streamed in audio and video to its website. Cooperation with the media in this day and age should accommodate approaches which depend on modern technology. I recall some years ago in my court we introduced a rule permitting reporters to use handheld recorders in the courtroom to tape the proceedings for the purposes of accuracy in subsequent reporting. To my surprise, that was thought on a national basis at the time to be a rather dramatic advance. We have in our Supreme Court here a practice direction relating to recording. I noted that in the first Julian Assange bail application, the district judge in London expressly allowed tweeting from the courtroom. The Lord Chief Justice of England and Wales has said this: how is the principle of open justice compatible with preventing an ongoing live and text-based dialogue to the outside world from a courtroom? If a reporter or members of the public is permitted to write notes to himself or herself in court and then file them from a telephone outside the court, what's the qualitative difference if they are permitted to do so when sitting in court, say by sending an email? If it's possible to file a story by email from a laptop in court, then why is Twitter any different? On the other hand, tape recordings are prohibited by statute. Why is Twitter, in the form of text-based transmission of the material from court, any different? In Queensland courts, laptop computers which don't communicate via a cellular network may be used during court proceedings, though obviously not by jurors. This capacity obviously facilitates the earliest online publication of court proceedings. Last week, on the 7th of February, the Lord Chief Justice of England and Wales released a consultation paper on the use of live text-based forms of communication from court for the purposes of fair and accurate reporting. It's an interesting paper worth reading. It highlights the risks attending, quote, the use of live text-based communications from court, particularly jurors researching their cases on the internet, and that such communications may be used by witnesses to find out what's been said in court before they give evidence themselves. The prospect of mistrials is emphasised. The consultation paper acknowledges the role of the media in relation to the courts, while noting broadening of the category of those who may use text-based communication from the courtroom for the purposes of commentary on proceedings in train. If I may read from the paper, the courts have long recognised the significant role performed by the media. The press are afforded seating areas in most courtrooms. Journalists are invited to make representations as to the imposition of reporting restrictions, and the Judicial Communications Office works with journalists and the media to assist them in the fair and accurate reporting of court proceedings. The media are admitted to certain proceedings in the family courts which are not open to the public. Treating the use of live text-based communications by the media as the paradigm case for adapting the rules to permit the use of text-based communications is simply a continuation of this approach. The paper continues, if the media are to be regarded as the paradigm case, it's necessary to consider who is to be classified as the media. Certainly accredited journalists and representatives would be included, so the identity of those wishing to participate in reporting is evolving with the technology by which those events are reported. Student newspapers, bloggers and social commentators may wish to engage in live text-based communications from the court, but would not necessarily have media accreditation. Non-accredited members of the media can't be presumed to have the same appreciation of the legal framework surrounding court reporting, or the industry standards set out by the Press Complaints Commission as accredited media representatives must be presumed to have. We in Queensland led the world, I'm told, some years ago by establishing Wi-Fi zones in courthouses. And I understand the backpackers are especially grateful for the free access they now enjoy while they rest having a smoke in the courtyard outside the courthouse in Brisbane. But so also, I believe, are practitioners for the electronic access they now enjoy from the courtroom to their office and chambers throughout proceedings. I expect the use the media, news stations in particular, have made of this free internet access has not only eased the media's job, but has also created a more user-friendly and interactive court environment. A good base for broader perceptions of how courts operate is the experience of those directly involved. In the digital era, litigants who come to court shouldn't be relegated to technology inferior to that which they use back at their offices or homes. And jurors should be informed by means relevant to the age. Although some critics of the modern jury system argue that jurors lack the intellectual capacity to make increasingly complicated determinations of fact, the empirical studies suggest that it's not so much the intellectual capacity of jurors which is the problem, but rather the manner in which the evidence is presented. In other words, any fault rests with the lawyers and the judges. We must continually reassess the way we communicate with jurors to multiply techniques to ease the jury's fact-finding process. Charts, flow sheets, written summaries, video reenactments, computer-based crime scene analysis, increasingly a feature of our approach, are movements in that direction. Simple expedients can produce disproportionately beneficial consequences. I was amazed at the dramatic improvement to criminal trial presentations wrought by the simple document viewer in displaying documents in magnified form. But we also need to be alive to differences among the generations and age groups in the manner in which information is optimally assimilated. Juries increasingly include members of generations X and Y. Whereas baby boomers most generally have informed themselves by listening and reading the printed word, younger citizens are generally more interested in electronic forms of communication, the internet, mobile phones, etc. The prospect of best informing your subject will be enhanced if you use his or her preferred means of communication. Juries reflect a mix of ages, and so the means of communicating with them could involve a mix of techniques. The modern approaches just mentioned tend to show that, but we must not stop there. Effective communication rests at the heart of the advocate's mission of persuasion and the trial judge's instructions. The experience of participants in court proceedings will generally seep out into the broader community, so that when courts do things well, the message will to some extent get around. More likely, of course, if courts are felt by the participants to have got things wrong. The real circuit breaker in relation to the matter of understanding, thence confidence, can only be the more active presentation of what courts do. And modern technology certainly does provide new mechanisms for exploration and exploitation. The internet era has produced dramatic changes in the way hallowed institutions go about their work. Art galleries and museums, for example, but also the courts. No longer do judges correspond by letters and memos. Case management is conducted by email between lawyer and list manager. Orders are recorded by consent without the need for attendance by lawyers at the courthouse. In substantial litigation, disclosure of documents is managed electronically. Trial dates are sought and allocated electronically. But all of this relates to basic contemporary efficiency. The media court interface arises particularly in relation to the way we're beginning to conduct long and difficult trials, especially those which involve lots of documents. Queensland was the first Australian jurisdiction to develop an electronic trial capacity within its courts. That began in 2007. There had previously been e-trials, but they were set up by external service providers and paid for by the parties. The first in-house e-trial was in a commercial matter, Cove Corp and Indigo Projects, in 2007, to be followed by two highly visible trials in the criminal court, the Wickenby prosecution of Hargraves and Stoughton, and the trial of Dr. Patel. There have been e-appeals. We provide computer monitors for judge, judge's associate, witness, 7 for the jury and 2 for the media. An e-court book stores the documents. When a particular document is needed, it's displayed for all to see, including the media, and the public have their own large screen. An expansion-reduction capacity means that parts of documents can be shown. Documents can be compared and contrasted, placed side by side on the screen. Spreadsheets and tables can be produced and displayed electronically and hyperlinked to relevant documents. When that is allied with real-time reporting of evidence, with the record created instantaneously, avoiding the delay which used to accompany any necessary checking of evidence previously given, the overall product is streamlined and progressive, aiding understanding of participants and observers alike, and satisfying a need to comprehend and publicise in the context of 21st century technology. In fact, 2 criminal trials will run concurrently in the Supreme Court of Queensland in Brisbane from next Monday on the e-trials basis. Electronics also relieve pressure at the appeal level. Access to the e-court book, complete with transcript and exhibits, reduces cost and preserves forests. The Patel appeal is to be conducted electronically in Brisbane next month. Another way courts can assist the media to get an accurate report to the public quickly is the publication of civil judgments and criminal sentencing remarks on the court webpage without delay. In Queensland, we offer the newspaper a link so that an online user can transfer to the full text of any judgment if desired. That is, in any case, the object, although the newspaper hasn't used that facility very much. Now, I described the way we are doing things these days. Contrast the ancien regime. The document would be produced, shown to the witness, tendered, passed to the judge, passed back to the associate for marking, then as necessary passed from one juror to the other around the jury box. Then we go to the next document. Had that time-consuming process been followed in the Hargraves and Stoughton criminal case and the Dr. Patel criminal case, trials which consumed only a few weeks would have lasted, it's felt, many times longer. The first Hargraves trial heard 18 days of evidence. The trial judge estimates that absent that technology, that trial would have lasted at least 6 months. On the civil side, the Supreme Court, when I joined the bar, was often not timely in the production of reserved judgments. Now almost all are published within 3 months of the conclusion of the hearing, something which must itself foster confidence in the responsibility and reliability of the process. And I'm a little embarrassed to have to highlight that because it really is something which should go without saying. For all these initiatives, ladies and gentlemen, criticism of the courts, like death and taxes, is guaranteed. One can only hope it will become better informed, and I express gratitude for the media's discharge of its responsibility in that regard. To the extent that the courts may by some reasonable means assist you to inform our constituency, we stand ready to assist. Thank you.
Thank you very much, Chief Justice. Ladies and gentlemen, it gives me great pleasure to introduce our next speaker. The program seems to be in the correct order and the poster might be in the wrong order, so Senator, I hope you'll forgive us if we next invite Mr Hartigan to speak. John Hartigan is the Chairman and Chief Executive of News Limited. He's also the Chairman and Director of Sky News, who I understand are with us today, and I'm sure that there's no connection between those, between the presence of Sky today and Mr Hartigan's presence amongst us. We're very pleased to have you, Mr Hartigan. It's great to have you at Bond University, and we're looking forward to hear what you've got to say. Of course, the students in particular will be keen to hear what you've got to say. They probably be pestering you during the break for details on about job openings at News Limited and what have you. Once again, we're very pleased to have you. So, if you could all join me in a Queensland welcome for Mr. John Hartigan.
Thanks very much. Thank you, Professor and Chief Justice and Shadow Attorney. Thank you. Just have a glass of water first. Thank you very much indeed for asking me to speak here today. I believe this is a very important opportunity, and frankly I think it's time that we did speak. You invited me to talk today about the courts and the media in the digital era, and I'll certainly do that. But more importantly, I want to speak about open justice. As we all know, it's the fundamental premise of a democracy. The integrity and the independence of courts can only be upheld when they are open to full scrutiny. A lack of openness invites a lack of respect and confidence in the system. I believe that among some members of the judiciary, there is a sense that openness is contrary to the administration of justice. And I argue that this is wrong, indeed very wrong. Without openness, the administration of justice is simply not possible. The public has a right to understand and witness in action the laws that govern them. Not everyone agrees with that, of course. Indeed, the quote from Otto von Bismarck is, people who love sausage and people who believe in justice should never watch either of them being made. I much prefer the insight of your learned colleague, Geoffrey Robertson, this week when appealing for an open court for Julian Assange's trial in Sweden. He said, "No man ought to be tried in holes or in corners or places when gates are shut and barred." It is through the media that most Australians are kept informed about most of the things that affect them, including how we are governed and how justice is done and how it is seen to be done. This is why I believe our relationship is indeed so important. When we get it right, we work well together. But when we have issues, boy, we do indeed have issues. Today I'd like to address some of these issues. There are important matters to discuss, important ideas to share in order to face the future together. We need to better understand each other and work together better. Thank you. Today I'm going to question that reality of open justice and challenge you to consider how we can really achieve it. But first I'd like to get personal. As the slide said, I'm the chairman of and CEO of News Limited, have been for a little over 10 years. And indeed, I'm the chairman of Sky, and no, it's purely coincidental that they're televising this today. But first and foremost, I'm a journalist, and I have been for 45 years. A journalist is what I am, who I am, and what I will always be. I started fresh out of school, got a job as a copy boy with Fairfax in Sydney. It wasn't glamorous. I placed bets for old journos. I picked up their takeaway food and smokes, and thankfully lattes weren't in vogue then. It took me 2 years to get my cadetship, and finally I cut my teeth as a police reporter on the beat of the streets in Sydney. I knew then, as I believe today, that courts are a great source of great yarns. At all levels there were scandals and misfits galore, and that was just among the prosecutor ranks. The courts were also great for contacts, invaluable lifelong contacts among the legal and enforcement agencies. In fact, I owe the New South Wales court system for one of the most enduring contacts of my life. As a young reporter, I was sent west to cover the case of a negligent doctor in country Cobar. City lad, big country town, fresh air and cold beer. Inevitable distractions that made 2 weeks inside a stuffy courtroom distinctly unappealing. Luckily, I met a young reporter, fresh-faced from the Daily Liberal in Dubbo, who agreed to file for me from one of the morning sessions to my news desk, allowing me a delayed start to the day. Blame it on the fresh country air. He was an ambitious young gun who had his sights set on big city journalism. He wrote with flair. The news desk thought I'd made it as a court reporter. It was my best work yet. The ambitious young bloke who made me look good was Col Allen. Today he holds one of the best journalism jobs in the world. He's the editor-in-chief of the New York Post and a former editor of the Daily Telegraph in Sydney, or in New South Wales. He's also a lifelong mate. My career has seen postings in New York and London, and I've edited papers in Queensland and in New South Wales. As an editor, I've always regarded the courts as a source of some of the greatest fodder for our news pages. This is Middle Australia writ large. You don't get a better snapshot of society. And Middle Australia is dead bang in the middle of our audience. So a few words about the company and our audience. We have around 140 newspapers in Australia. That includes one national broadsheet, 15 daily and Sunday metropolitan newspapers, 107 community titles, and 21 regional newspapers. We've also got 27 magazines, from Vogue at one end to Golfing Digest at the other. We run over 100 websites and now have iPad applications for 5 of our state websites and the Australian. 7 in every 10 Australians read a News Limited newspaper or visit one of our websites every week. Our national and metro mastheads are read by over 8.5 million Australians each week. That's far more than the grand finals or the finals of MasterChef. I'm giving you these figures today not to boast, but because understanding our reach is key to this discussion. This level of connection to people is why our relationship is so important, and frankly, the reason why it can be so much better. I know that some of you are fierce critics of how we report the news. You say we focus too much on the outcomes and not the reason process. You say we cater to shock jocks and rednecks. It's all about what, not how and why. You may not enjoy or agree with the headlines that we publish. You might feel uncomfortable about what investigations we uncover. You may vehemently disagree with an editor's decision on how a story is treated. I get that, and I will agree there is always room for improvement. I do encourage our editors, however, to be bold and to challenge, and I certainly don't apologise for that. I believe we get it right more often than not, and I'm not alone. Allow me a quote from the Victorian Chief Justice Marilyn Warren from April last year. She said, "The capacity of journalists to reduce to a very confined form the salient points of a case and the reasons for a judge's decision is often astounding. The quality is consistently high and often superb." Now that's the sort of verdict that I like. But sometimes you make our lives very difficult, and I'm convinced that it doesn't need to be that way. Let me refer again to my old colleague, Col Allen, in New York. In the past 5 years, his legal counsel at the New York Post has not seen a single suppression order. Not one. In Australia, our legal counsel faced more than 500 orders in the past 12 months. 270 of those in Victoria alone. That's a lot of time and money for us. But they were just the ones that we know about. We estimate that at any one time there are more than 1,000 court suppression orders preventing publication of certain facts from court cases. While some of these, for example, protecting the identity of an undercover police operative, are clearly justified, Many are not. Orders are being used to close access to courts and suppress details in cases, often with scant reason. For example, a Victorian court issued an order to stop identification of a major public figure accused of fraudulent company dealings. It then imposed another order to stop the media saying it had been gagged. I question whether suppression orders should be used to protect public figures from embarrassment. And should an entire anti-terrorism trial be closed even though not all the information is subject to national security? Courts frequently view the media as a nuisance. No doubt we are sometimes, but denying access to the workings of the justice system is dangerously short-sighted, I would say. Suppression orders are our bugbear, and the current model suppression order legislation sends a shiver down my spine, and not in a good way. This legislation is fatally flawed and has the capacity to send open justice behind closed doors. Open justice is not defined as the primary objective in the legislation. It must be. Without the presumption of openness, the definition of public interest can easily be exploited and manipulated. It allows wider scope for the accused to seek to suppress all or part of the hearing, and thus potentially allows for all these orders to be used to protect the privacy of those before the courts. Transparency is critical. Most Australians gain understanding and knowledge of how justice is done through the media. People need to have confidence in the legal system, and this can only happen through exposure. Let me give you a few examples of what I believe suppression orders and how they're strangling open justice. Firstly, an order which meant it was 2 years before the media could report that gangland killer Carl Williams was found guilty of murder. The ongoing controversy over New South Wales Children's Criminal Proceedings Act, which prohibits the identity of children even when they are dead. Unless we had fought it in the case of Tegan Lane and her mother Kelly Lane would have remained a dirty secret in New South Wales. Marcus Einfeld successfully applied for a suppression order prohibiting publication of a record of interview with Vivian Schenker. Then the application and order was suppressed. 8 hours later, our application was successful and the order was lifted. As we know, Schenker became the prosecution's star witness. In South Australia, the name of an 18-year-old accused of murdering 3 family members in a small community was suppressed for 3 months, although his name was circulating freely on social networking websites following his arrest. And the suppression order of a witness's name in a terrorism trial, although the identity and his evidence were already in the public domain. And very close to home, the suppression of the Weekend Australian magazine in May last year because the judge believed that a jury hearing a murder trial in Melbourne would be influenced by an article on an unrelated murder in South Australia. An unrelated murder. 70,000 copies of the magazine were withdrawn from circulation in Victoria at a cost of hundreds of thousands of dollars. Little wonder that it had become known as the stupid juror rule. Our legal teams waste valuable time and dollars fighting orders where all too often there is no evidence of an adverse impact on publication. Quite frankly, there is too much fighting. Unlike the US system, where most judges will grant same-day access to documents and exhibits and only deny access in the most extreme of circumstances, our reporters must fight tooth and nail to get their hands on material. Consider the example of a civil case in the New South Wales District Court. Our journalist was asked for access to the court file of a case that she was covering. She wanted to read the affidavits and reports people were being cross-examined on in open court. She did so she could provide a fair and accurate report of the proceedings. The duty registrar knocked back her application. Why? Quote, "The registrar takes the position that the matter is still before the court and therefore outside the non-party access rules," unquote. Despite a written submission including references to judgments about access in similar cases, the answer remained no. The reporter was told to take it up with the judge. Hire a lawyer and go to court so the court officer can be told to release a file containing evidence in a court file. Ludicrous. I say simply ludicrous. As is this. The same reporter wanted details on an interstate case. The Supreme Court in Canberra said documents would only be released to her in person. No faxing, no emailing, no posting. Her response? It's often easier to report on a case before a US court than one in Australia. And then there are the takedown notices. We are seeing an increasing willingness of judges to give order to remove archived articles from our websites for fear jurors will be influenced by what they read. During the third murder trial of a certain notorious underworld figure, we were asked to take down all of the mentions of him. It took us 6 days to track it all down and remove it. We appealed and we won, but the information was not restored. Who was involved? Well, I'd like to share it with you, but even in this forum, I'd be breaking the law, as his identity is suppressed. I think it's time that we gave jurors more credit to ignore what they read outside the court and showed the jury system more faith. Courtroom directions leave little doubt about jurors conducting their own research. I'm sure some of you probably think that the media has too much freedom. Too much, perhaps. But the fact is we work in a highly regulated environment. Across Australia, there are more than 500 different secrecy provisions in various pieces of legislation that restrict what we are allowed to know and what we are allowed to report. But there's some change ahead. 4 years ago, 12 of the biggest media organisations in Australia joined a coalition called Australia's Right to Know. We are beginning to make inroads. Some laws are being changed to allow more openness and more transparency. Even the military is becoming more open. Next stop, the courts. I certainly hope so. The public's right to know is a passion of mine, and I could speak to you about it for many hours. But you've asked me to talk about the impact of the digital age and our relationship, and I will. My advice, embrace it, don't fight it, treat it with respect, get to know it and trust it. After all, it's already here and it needn't come between us. We must be aware that it brings increasing scrutiny of the media, of the judiciary, the Parliament. We are being held to higher standards than ever before. And no one likes scrutiny. We're all guilty of that, but we are going to have to live with it. Social media is redefining courtroom reality, and I do understand your concerns about its potential to undermine the jury system. As you'd be aware, there are already plentiful examples of its infiltration, such as the juror in the US who sent a key witness a Facebook friend request, or the juror who posted on Facebook how, quote, it was going to be fun to tell the defendant that they're guilty, unquote. She copped a $250 fine and a 5-page written essay on the constitutional rights of a fair trial. Not sure about the penalty in the modern era. When Julian Assange appeared in court in London late last year, the judge ruled that journalists could tweet throughout the trial, providing it's quiet and doesn't disturb anything. Here in Queensland, jurors can access laptops to reviews, as the review exhibits, as the Chief Justice said. In Victoria, audio of judges' sentencing remarks are available in major criminal cases. Small steps towards the new era, but we still have a long way to go. But before Twitter, before Facebook, I believe we've got to revisit the cameras. Court artists drawing sketches of defendants do not belong in a digital age. Still cameras do, as do television cameras. Without flash photography, with rules to protect vulnerable witnesses, yes, of course. Also, again, to cite the US, the state courts in New York are increasingly open to allowing still photographers for opening statements and sentencing hearings. Let the public see what you do. Let them see the complete picture and proper context. Let them see justice being done. Will TV cameras release someone's inner judge duty? Perhaps. But that's exposing an individual personality defect, nothing more. It does not corrupt justice. Fortunately, we're already witnessing a shift in acceptance towards television cameras among some judges. I was heartened by the recent comments of Western Australian Chief Justice Wayne Martin following the decision to allow cameras to record a murder trial in the court for an ABC documentary. Quote, "Anything that increases information available to the public about what happens in court is a good thing," he said. In September last year, TV cameras broadcast live and uninterrupted the reasoning of Justice Megan Latham in sentencing murderer Des Campbell to at least 24 years in jail for throwing his wife off a cliff. It was the first time an Australian court allowed TV cameras to broadcast a murder sentencing live. The result was a better public understanding of the reasoning, not an abridged version on the 6 p.m. news that left people wondering. Right now, I'd argue that reform to the court system is required if we're going to work together more effectively. Reforms which correct the imbalance between open justice and secrecy. We've already seen important changes to the freedom of information legislation federally and in several states where they put new onus on disclosure, not concealment. And we have seen encouraging moves to protect whistleblowers in the public service from prosecution if they act in the public interest. And in cases where journalists reveal Commonwealth secrets provided by confidential sources, the burden of proof now requires officials on witch hunts to show why identifying the journalist's source is in the public interest. So here's what I'd like to see changes in relation to the courts. Still cameras and television cameras allowed in courts for opening remarks and sentencing judgments. Real-time access to transcripts and documents used in court. Rejection of the model suppression order legislation as it currently stands. The presumption of openness is a must to be given priority. Removal of current takedown orders. And I'll briefly spell out why. By banishing cameras from court, the opportunity for the public to see justice being done is diminished. Neither journalists nor the public are barred, only television, the medium that could shed the most light and the largest number of people on the court's reasoning for sentencing. Please don't protest that the media doesn't provide proper examination of the judgments and the sentencing decisions and then stand in their way. Of course, cameras may not be appropriate in every case, and safeguards already exist for judges to hold private sessions where media are excluded and where identity is an issue. At the very least, sentencing remarks in criminal cases and judgments in civil cases should be televised. It's not about vaudeville, it's not about ratings, it's about public policy, good public policy, and it's about justice. We need more real-time access to transcripts and documents that are used in court. In a modern era, it is simply ridiculous that real-time transcripts are not more readily available. And I take heed again of what the Chief Justice mentioned is the case in Queensland. We need a system of cooperation and understanding, such as the US, where same-day release of exhibit material in a recent criminal case allowed audio of a 911 call to be run on a news website that afternoon. We live in an immediate world. Reporting on court should be no different. Immediacy of information is critical, not a two-day battle for access to public documents. Most of all, we need to halt the suppression order juggernaut. And the first stop must be the secret state of Victoria. The current model suppression orders in legislation is not the answer. I urge all states not to adopt this deficient and flawed legislation. There is already too much readiness to ditch open justice in the supposed interests of administering justice. This legislation must be amended so that open justice is the primary objective. The presumption of openness must be paramount. Secrecy must only be allowed when it is absolutely necessary in the interests of justice. We must immediately end the nonsense of takedown orders. They are unnecessary and ineffective. It is the modern equivalent, I would argue, of burning books. If a juror had failed to heed the direction of the court, he or she will embark on an internet search. Takedown orders will not prevent that. Articles will be accessible on sites far beyond the court's jurisdiction, and whether we take them down or not. Again, jurors must be given credit and guidance. We're at a critical point now. With collaboration and cooperation, we can achieve reform together and improve our relationship. At all levels of the system, we need greater appreciation of the media's role in reporting on the courts and less desire to block our path. Open and transparent justice depends on the will of each of you to drive the cultural change through the bureaucracy of the court system. Yes, it's about the impact of the digital era, but the real issue is more fundamental. It is about information and access. As it was when Lord Hewitt said so wisely, not only must justice be done, it must also be seen to be done. Democracy enshrines that the media be the eyes and ears of the public. These four key reforms will allow us to do so without being blindfolded or gagged. Let us not forget the wise observation of Lord Hewitt. Thank you very much.
Thanks very much. Well, thank you, Mr. Hartigan, and for a passionate keynote, I think, about the public right to know. Thank you for coming to Bond today to deliver it for our benefit. Our final keynote speaker this morning is not only a forgiving man, but a patient man. George Brandis has been a senator for the state of Queensland since the year 2000. He holds degrees in law and arts, majoring in politics from the University of Queensland, with first-class honours in both. Students take note. He also has a Bachelor of Civil Law from Oxford University, where he won the Sir Rupert Cross Prize in Evidence. Again, students take note. Prior to entering Parliament, he worked as a barrister and was appointed senior counsel in November 2006. He's the Shadow Attorney General. He's also Deputy Leader of the Opposition in the Senate. Please join me in welcoming Senator Brandis to deliver his keynote speech. Thank you, Senator.
Professor Kaiser, Chief Justice, Mr. Hartigan, ladies and gentlemen. I must confess that I am very seldom approached for my views about the latest in cutting-edge technology. I do not blog, I do not tweet. I am popularly rumoured to be the only member of Shadow Cabinet who does not possess a BlackBerry. I imagine I'm one of the last members of the Australian Parliament who still observes the practice of writing handwritten notes to constituents from time to time. But I do share with the Chief Justice one common experience in relation to the development of technology in the courts. It was in 1997 in the important equity case of Donnelly and Donnelly, where I appeared for a client in a case conducted by the Chief Justice, that real-time court reporting was pioneered for the first occasion in the Supreme Court of Queensland, a fact that was recorded by His Honour in a gracious note at the end of his reasons for judgment in 1998, One Queensland Reports. I want to make a few observations today in relation to the value of transparency. Transparency and openness are invoked, as we've just heard them invoked, by Mr. Hartigan, sometimes as if they were almost absolute values. And undoubtedly they are important, indeed fundamental, democratic values. But when it comes to the courts in particular, I think the situation is a little bit more complicated than that. It is to us today inconceivable that the institutions of our democracy could exist without rigorous public scrutiny. And that scrutiny is provided, of course, by the media. Ever since the day in 1787 when Edmund Burke, the member for Bristol, turned a languid eye to the Strangers' Gallery of the House of Commons and observed the reporters there and said, in those famous words, there were 3 estates in Parliament, but in the reporters' gallery yonder there was a 4th estate more important than the other 3. The media has been an informal part of our Constitution. The development of the media as a popular form has paralleled the development of democratic institutions themselves. First, in relation to the proceedings of Parliament, and shortly afterwards, in relation to the covering of proceedings in the courts. It's unthinkable today, but it was the case at the end of the 18th century, that both Parliament and the courts conducted their proceedings in secret. And the development of transparent scrutiny of parliamentary proceedings and court proceedings owes its origin to a particular time and point in history. The years commencing with the American Revolutionary Wars in the 1770s and concluding with the first Reform Act in 1832. The last time the House of Commons sought to punish anyone for reporting proceedings in Parliament was in 1771, when a printer called Miller was sent to the Tower of London, but the judges refused to entertain the proceedings against him. We can trace to that case in that year the origins of current notions of freedom of the press. The idea that parliamentary reports should be made developed at the end of the 18th and the beginning of the 19th century. The idea that the courts should be the subject of media scrutiny came a little bit later. It came in particular in the 1830s, and it owed its origins to the decision in 1832 to repeal the stamp duty on newspapers, leading to an enormous expansion in the 1830s of penny newspapers available in London and the great English cities. Editors searching for content in those newspapers lit upon the courts as a ready source of human drama and public entertainment. Although, of course, today we think of him primarily as a novelist, in fact it was Charles Dickens who began his life as a court and parliamentary reporter who was at the forefront of that movement and introduced descriptions of cases currently before the Old Bailey into the English newspapers of the 1830s, many of which are collected in that now little read work of his Sketches by Boz, and subsequently expanded that coverage into fiction. Such memorable instances as the trial of Fagin in Oliver Twist and the rather unpromising construction of the plot of a great novel from a chancery suit. Dickens was the first important English writer, both as a journalist to publicise the proceedings of the court and as a novelist to make them the basis of his fiction. The way in which the media have reported court proceedings did not essentially change in the more than the century and a half between the 1830s and the 1990s. There were newspaper reports of the proceedings, and there were sometimes descriptive pieces of the personalities involved. But the nature of the mediation of news from the courts to the public remained largely constant for 160 or so years. And so the courts, like Parliament, began to be seen as institutions whose proceedings were of course a matter of public interest and whose performance, as Mr. Hartigan has said, could only be improved by the public having greater information about them and scrutiny of them. When in 1964 he wrote his great book on legal theory, The Morality of Law, Professor Lon Fuller listed the transparency of justice as one of the core values of a functional justice system, and listed inadequacy of information about reportage of and the administration of justice as one of the 8 ways in which a legal system might fail. Yet, transparency is not, as I said earlier, an absolute value, because there are some respects in which public information and coverage of the courts might limit either their function or other important competing public values. Let me fast forward to the beginning of the 21st century and reflect upon the implications for the courts and their operation of the explosion of content facilitated by digital technology, which have challenged both the courts, the legal profession, and, of necessity, legislators. As is often the way, the most striking examples have come from the United States. A recent article in the American Bar Association Journal gives the following examples. A woman who live blogged the Phil Spector murder trial from the courtroom. A blog that followed the Duke University lacrosse team rape case, which some lawyers credit for the acquittals. Allegations that Michael Jackson funded a blog during his child molestation trial, which directed fans to the courthouse at strategic times and posted photographs and home addresses of the prosecution team. The implication for the unlimited use of technology and the publication of unlimited information in relation to proceedings in the courts can be disturbing, but they can also be salutary. In the Jackson and Spector cases, digital media were used to defy non-publication orders and intimidate the prosecution. However, in the Duke University case, the blogger, who was in fact a history professor, effectively broke the stories that the mainstream media had failed to pursue. His review of the prosecution documents revealed that the district attorney had filed charges with insufficient evidence and had ignored exculpatory material. That ultimately led to the district attorney being struck off. In theory, one American commentator noted, these digital communications can't influence a trial because they shouldn't sway judges and jurors. But in practice, even those communications with very few readers deliver a message that the courts are unable to control. When people write for a newspaper, well, they're not always objective, at least in theory they are trying to be, he said. There's no requirement for these bloggers to try and be objective. And if something goes into print, it sort of becomes gospel to some people. Another commentator writes, all these issues of jurors seeing media materials they're not supposed to see have been with us for years. But there's been a sudden change in the tools we're using, and that takes us to a new dimension. The explosion of published commentary clearly poses sharp challenges for those charged with the administration of our justice system. It is clear that any solution to those problems will need to balance the salutary and essential effects of free communication with mechanisms to ensure some measure of responsibility for what is said. In other words, courts and lawmakers need to find a way to reconcile the public interest in the reporting of news and the creation of literary and educational material against the threat that some communications may pose to the proper administration of justice. Those who champion freedom of information, as Mr. Hartigan has done through the Right to Know campaign, at the same time champion the protection of journalist sources through shield laws, a cause which I have taken up, as Mr. Hartigan knows, in the Commonwealth Parliament and is currently the subject of a private senator's bill standing in my name. But just pause to reflect for one moment on the different values that those two objectives serve. Freedom of information suggests, as its name dictates, as the term dictates, that information should be freely available in the public arena. Journalists' shield laws, in the service of that ultimate objective, would require that information be suppressed from the courts and from the public. That is, the identity of a journalist's source, and hence, potentially, the capacity to challenge and authenticate the report upon which the journalist relies, or the source upon which the journalist relies, in the name of a broader public good. As I've said, that is a course or a measure which I support and indeed promote. But let us not pretend they are the same thing. They are different things, in the service of the same ultimate value. The genesis of the current Shield Laws legislation before Parliament in recent times arises from the Harvey and McManus case, when two News Limited journalists indeed, Mr Harvey and Mr McManus, were charged with contempt of court for refusing to reveal their source for an article published in the Melbourne Herald Sun. They were ultimately convicted and fined in 2007. I took up the case in 2005, and I said this, that the case squarely raised the issue of whether the law should be reformed to give some measure of privilege in legal proceedings to journalists to enable them to protect their sources. More broadly, it highlights the inconsistency in the treatment which the rules of evidence give to information imparted in confidence, and provides an occasion for the whole area of the treatment of professional confidences to be reformed. Now, I have for a long time been of the view that the law in this area is riddled with irrationality and inconsistency, and has long stood in need of comprehensive reform, which gives equivalent status to a range of professional relationships. At common law, there were only two relationships which were absolutely privileged from disclosure in courts: marital relationships and relationships between lawyer and client. There were other forms of privilege as well, in particular the privilege against self-incrimination, the privilege now called public interest immunity, and the privilege of without prejudice negotiations. But those privileges were not based on and did not depend on the existence of a particular category of relationship. The doctrinal basis of the privilege in these two categories, that is, marital communications and lawyer-client communications, was quite different. Spousal privilege was based on the ancient legal fiction ultimately derived from Christian theology of the unity of husband and wife. The doctrinal basis of lawyer-client privilege is more controversial, but most scholars agree that it ultimately derives from the principle that a lawyer is his client's alter ego in court, and therefore there must be absolute freedom of communication between the two. The justification is a functional one. The traditional justifications for the extension of relationship-based privilege to only those two types of relationship has never been satisfactory. The basis of a spousal privilege was a legal fiction, while the basis of legal professional privilege cannot explain why it extends to non-curial lawyer-client relationships. But more importantly, it entirely ignored other professional or intimate personal relationships which merit protection. Most famously, the common law gave no protection to the relationship between priest and penitent, so that a Catholic priest administering the sacrament of confession could be required by the law to reveal the secrets of the confessional on pain of imprisonment for an indefinite period, notwithstanding that to do so was a fundamental breach of his priestly vows and a mortal sin. There's traditionally been nothing to excuse a doctor from refusing to reveal the medical secrets of his patients, even though they are imparted to him in the privacy of his surgery, and notwithstanding that to do so would be a serious breach of the doctor's professional ethics, for which he would be exposed to professional sanction. And as the Harvey and McManus cases reminded us, there is nothing to protect journalists who, in conformity with their own professional code of conduct, are bound to protect confidential sources. The Evidence Act currently provides that the court has discretion to direct that evidence that would disclose a confidential communication made to a journalist or the identity of the source may be excluded. Such a direction must be made if the court is satisfied that the source might be harmed if the evidence is adduced, and that the harm outweighs the benefit of the evidence being given. The existing privilege can therefore be described as a guided judicial discretion. Any claim to privilege is a matter to be determined by a judge by weighing the listed discretionary factors. This has been criticised as providing very little certainty as to whether a disclosure is protected when it is most needed, that is, in advance. The position in New Zealand and the United Kingdom presumes that the communication between journalist and source is not subject to disclosure unless the party seeking to disclose can establish that the disclosure is necessary. For example, Section 68 of the New Zealand Evidence Act provides that the court may not order disclosure unless it is satisfied that the public interest in the disclosure outweighs any adverse effect on the source or on any other person, and the public interest in communication of facts and opinion to the public by the news media. The former Commonwealth Solicitor General David Bennett told the Senate committee which reviewed this issue recently that, in his view, there is much to recommend a position that offers a higher degree of certainty to reporters and their sources in advance. This is the position that the bill that I introduced into the Senate late last year adopts. The continued restriction of privilege claims is anomalous. The Coalition adopts the formula in the New South Wales Act, that is the New South Wales Evidence Act, which would not only restore uniformity, but would avoid arbitrarily confining the circumstances in which claims for privilege may be justifiably asserted. As well, it brings this area of law more closely into uniformity with the courts of equity in their protection of confidential relationships. Finally, the bill extends the application of those new privileges to all proceedings in any Australian court for any Commonwealth offence. Because the Commonwealth does not have a dedicated court of criminal jurisdiction, in nearly all cases the relevant proceedings are brought in state or territory courts. Interestingly, the existing regime was tested only recently in the Supreme Court of New South Wales in a defamation action brought by Mrs Helen Liu against Fairfax newspapers. The action relates, as you may have read in the newspapers recently, to the story of alleging an improper relationship between Mrs Liu and the former Defence Minister, Mr Fitzgibbon. Justice McCallum ordered the disclosure of the emails between Fairfax journalists and their sources on the basis that the documents provided to the journalists may have been forged. His Honour told the parties that she was not unsympathetic to the protection of journalist sources, but that the allegation that the documents were forged took the matter out of the ordinary type of case. In my view, the result would probably be the same under the regime proposed by the bill I brought before the Senate. Now, I wanted to dwell on, at a little length, on the journalist sources, the journalist shield laws issue, to illustrate the point that I foreshadowed earlier, that claims to openness and transparency are nowhere nearly as simple as they appear. They involve weighing a number of different interests, none of which are trumped by a claim of the public desirability of openness in judicial proceedings. In that respect, Mr Hartigan's view is, I would respectively suggest, a little absolutist. There are in fact two sets of balances to be considered. The first is the balance between the public interest and private rights, the sorts of private rights which take the form of some of the existing privileges which the courts enforce, such as spousal privilege, such as lawyer-client privilege. But even if we move beyond weighing the public interest against private interests, there is a variety of different public interests to be considered as well. May I suggest to you that there are three, none of which is absolute, all of which have to be weighed against one another. The first public interest, I would say, and agree with Mr Hartigan, in the overwhelming number of cases, the most important public interest is in institutional transparency, the right to know what goes on in the courts. The virtue of judicial institutions identified by Lon Fuller in The Morality of Law. But it is not an absolute value, and on occasions it must yield to two other values. The second of those two other public interests, the second of those public interests is the public interest in the due administration of justice. There may be occasions, as I think Mr. Hartigan and others would acknowledge, and as other commentators have acknowledged, when the public interest in the due administration of justice, which for practical purposes translates as the public interest that the courts get it right, that the innocent be acquitted and the guilty be convicted in a criminal case, that a meritorious claimant have his civil claim vindicated in a civil case, might potentially be defeated by the unlimited provision of information which, for example, might corrupt jurors' deliberations. The public interest in the due administration of justice is, in my view, at least as important a value as the public interest in institutional transparency. And it is by no means clear to me that on those rare occasions when they might come into direct conflict, that the public interest in transparency should not yield. And there is a third public interest that has to be weighed in the balance as well, and that is public interests beyond the internal court processes themselves. The second public interest of which I've spoken is about the way in which the courts achieve a just outcome. But beyond the intramural considerations of disposing of the case in a just manner, there are public interests beyond the courts themselves, of which the most obvious is national security. There are some trials which, of necessity, involve evidence which cannot be placed into the public arena without doing credible and serious harm to national security, or without doing credible and serious harm to other important public interests. Those occasions will be rare, but they exist, and that is a public interest that must be weighed in the balance as well. So, in conclusion, ladies and gentlemen, allow me to declare myself to be, as Mr. Hartigan knows me to be, a very strong friend of the Right to Know campaign, but not an uncritical one. As one of the twin objectives of the Right to Know campaign, that is journalists' shield laws, itself reveals, this is by no means simple, and valuable interests may be better served by the withdrawal of information from the public domain and from evidence led in court, in the case of journalist shield laws, that being the identity of the journalist's source, than by adhering to the language of transparency and openness as if they were absolute values. They are not absolute values. They are values which involve strong presumptions, but which may, on occasions, yield to equally important and greater values themselves. Thank you.
Thank you very much, Senator. Ladies and gentlemen, you've heard three perspectives on the relationship between the courts and the media in the digital era. Chief Justice de Jersey, Mr John Hartigan, the Chairman of News, and Senator Brandis, the Shadow Attorney General. Much to chew on, much to reflect on, much to think about in the rest of the sessions that we have today. I hope you'll join me in thanking all three of our keynote speakers together for the insights that they've shared with us this morning.
For more information, visit bond.edu.au/iTunesU.